Good evening and welcome to this latest edition in the Elephant's ongoing conversations, the elephant in the room. And today it is my pleasure and my honor to be joined by Jill Cottrell Ghai, who is a lecturer in law. Jill is also a director and founder of the Katiba Institute. The Katiba Institute is Kenya's leading public interest litigation non-governmental organization that has led in a number of groundbreaking public interest litigation cases here in Kenya. And Jill has been an advisor in the constitution-making processes in several countries around the world. Karibu sana, Jill. Very happy that you've been able to join us this evening.
Thank you very much, John. It's a great pleasure to be virtually here or there.
Jill, you've opined on and written about and advised on the 2/3 gender rule, on which the president of our Supreme Court, Chief Justice Maraga, issued an advisory a week ago now to President Kenyatta, essentially to disband Parliament and go into elections, because we haven't been in conformity with the 2010 Constitution. And I was wondering whether you can give us a bit of context as to the journey that has brought us to this very consequential advisory by the Chief Justice.
Certainly. It's a longer story than you might think. Ever since the very first draft of the Constitution, the one by the CKRC in 2002, there have been provisions about having a decent representation of women, but also of other sections of society. But of course, the issue of women has got the most attention. Perhaps we haven't given enough to the issues about persons with disability and minorities, marginalized communities, and so on. But this, at least, fairly clearly centers on this particular issue of representation of women. And the CKRC said at that time they were using the language of at least 1/3 women.
Yes.
The converse or the inverse about not more than 2/3 of either gender was introduced at the Bomas phase.
Correct.
Actually, it's been quite useful. It sounds a bit technical, but actually women have been able to make good practical use of it in terms of saying the number of men is actually more than 2/3, especially when you come to a situation in which you're talking fractions of men, you know, like the Supreme Court, where there's 1/3 is going to be 2 point something, and they've only got 2 anyway. So that the provisions have been there right from then. They have moved around a bit and in different bits of the Constitution, and the problem of how to do it, I think, has been there all the time.
Yes.
And that, of course, was the real issue. And indeed, also in every draft, there's a list of things that have to be done in terms of passing law at the end of the Constitution in the 5th schedule, with a timetable.
Yes.
Actually, there is nothing in that list which actually says by such and such a date we have to achieve not more than 2/3 women. And so there wasn't that precision. The idea is very clear, as indeed is the notion of at least 5% of persons with disability in various organizations. That's another fairly precise provision which hasn't got, as I said, enough attention. Until I was sort of rereading stuff from the Committee of Experts today, I'd forgotten that the whole idea of this business about possibly doing away with Parliament if it hasn't managed to do this goes back to the Bomas Constitution as well. And it is a problem, and other countries have faced it. If you tell Parliament to do something, how can you actually make sure it does something? Yes. So the idea that you can if they really don't do it, actually they can be done away with in the sense of being dissolved, is actually rather an ingenious idea. And as I say, it's been around since the Bomo's draft. But one of the earliest stages in this whole process was in the run-up to the elections in what turned out to be 2013. What was then the IECC, the Interim Electoral Commission, actually was trying to get its head around what it ought to do to try to make sure that this happened. And there were discussions, but they didn't actually get anywhere, and concrete ideas were never adopted. In the run-up to the 2013 election, the Attorney General went to court and asked the Supreme Court for a ruling on a couple of things, one of which was, what would happen if a parliament didn't meet this? Was it obliged to meet this requirement by 2013 elections? Very interesting decision. The former Chief Justice, William Tunga, had a line of his own, and his view was, if they didn't meet that requirement, they would be unconstitutional. The rest of the court said, we're not quite prepared to go that far.
Okay.
We think they should move in that direction. We think the Constitution expects them to move in that direction. But we think it's perhaps a bit much to ask them to do it in the next 3 months, which is the basic situation.
Yes.
And so the argument, I assume, was made to them, and they adopted it, that there is an article in the Constitution, and again, it's focused too much on women, which says that Parliament must pass legislation to promote the representation of women, persons with disability, marginalized communities, and so on. And they said, this is a useful peg on which to hang this. And that particular, there's Article 100 of the Constitution, that has to be done within 5 years. 5 years from the Constitution is 2015. Parliament did as they did almost everything. They added an extra year. They were allowed to add an extra year, and they did that. So 2016, okay. Come 2016, 2017, and so on. Nothing had happened. They tried a few times. I don't know how seriously they tried. But there were at least 4 attempts to introduce legislation to ensure that this happened. Maybe one also should remind ourselves that the Committee of Experts wrestling with this whole business, and each draft of the Constitution tried to deal with it separately.
Yes.
And the Committee of Experts second draft in late 2009, no, I think early 2010, was the only one that actually had a guaranteed arrangement, which was the one that we have at the county level now, which is that you have extra members to make sure that you've got enough of whichever sex is not there, and obviously women at this point. But if you remember, that draft of the Constitution had to go to a parliamentary committee.
Correct.
There's a lot of things to it. One of the things they did to it was to essentially take that out. And they left it at the county level because they didn't care very much about what happened at the county level. Yeah. But they desperately cared what happened to seats at the national level. And they removed it. And they went back to having what they like to call nominated members, a little bit on the lines of the ones that were there, and the same number as used to be there under the old Constitution. But of course, it was different in that there was now 47 county women representatives. But still, the Committee of Experts scheme would have been to have the extra members. It would have needed quite a lot in the first instance, but the MPs took it out. Right, so we got the Constitution without any guarantee of women, adequate number of, or adequate gender balance, let's put it like that. So, as I say, nothing happened several times, or not enough happened. They would introduce pieces of legislation, but they never managed to have a quorum to pass it. And they tried different measures, but the one that most appealed to the MPs was funnily enough, the thing which the committee of experts had put in and the MPs took out.
Yes.
It's really very ironical. This is not the only context in which people seem to be rather regretting what they did in 2012. The Committee of Experts, sorry, the BBI is also trying to roll back some of the decisions which were made then.
Yes.
They actually also tried to do away with this, how can one put it? I like to call it the nuclear option.
Okay.
One for dissolving Parliament if they haven't done their job. The MPs actually tried to do away with that too. But the Committee of Experts obviously decided that they'd better salvage something from this particular element of the shipwreck.
Yes.
And so they would restore the nuclear option if necessary. And it has served a good purpose.
Yes.
It's not entirely satisfactorily, but I'm sure everybody remembers times when Parliament was passing legislation and everyone was saying, oh, they're getting this law passed because they don't want to be sent home, right? Yeah. In other words, they weren't going to be dissolved.
Right.
But one that somehow the nuclear option never managed to convince them of was the necessity to pass this legislation, even though the Supreme Court had told them they had to do it by 2015, for which read 2016.
Yes.
So that's how we got to a situation in which in the run-up to the 2017 election, this came back to the court, and it was brought by people like Daisy Amdani and so on, and 2 or 3 organizations. And they got a very specific order under Article 261 of the Constitution from Justice Mativo, who said, today is like the 29th of March. By the 29th of May, you have to pass this legislation, or somebody can go to the Chief Justice and say, well, the Chief Justice should say, you haven't done it, you have to be dissolved. Yes. Well, that was very close to the elections, of course. Yes. And then there was an appeal to the Court of Appeal, and that didn't get decided until 2019. And the Court of Appeal agreed with Justice Mativo.
Okay.
And they said, the Court of Appeal said, now people can apply to the Chief Justice to activate this particular option. And indeed, that's exactly what happened and led to what some people are calling the advisory. I don't like that word, but it's called advice, but it's not advice.
Okay, that's what I was going to ask.
Direction.
Okay. Yes, I've seen lawyers, especially on social media, arguing about words. But for you, it's called an advisory, but it's an instruction.
Yes. Now, it is a bit of a contradiction.
Yes.
So it says the chief, if by the deadline, Parliament has not passed the necessary legislation, the Chief Justice shall advise the President to dissolve Parliament, and the President shall dissolve Parliament. Now, the word advise obviously is a bit at odds with the word shall.
Yeah.
But I think, and I haven't actually checked with anybody, but my sense is that they thought, you can't quite say the Chief Justice shall direct the President. It just doesn't seem right.
Yes, doesn't.
I'm absolutely convinced that the Committee of Experts and the drafters involved in dealing with the words, and I think the language still goes back to the CKRC, when they use the word shall, they meant a directive. It must happen.
Okay.
In fact, there was an effort by one of the leading drafters during the whole process to say, if we mean must, we should use the word must.
Yeah.
Legal conservatism won out. And so they're still using this, and there's still arguments about what does it mean to say shall and what does it mean to say may. But I'm fairly clear in my own mind, and the Committee of Experts' own report makes it clear that they considered that this was an obligatory action on part of both the Chief Justice and the President.
Jill, I am just a man off the street. The Chief Justice has essentially issued this instruction that the President should dissolve Parliament, that as it's currently constituted, it's unconstitutional. What does that do to all that the Parliament has gotten up to in terms of making laws, all the committees that have sat, all the reports that have been produced that have impacted on our lives since 2013, in this state of unconstitutionality, as it were? Does it have that sort of reverse impact in terms of those who may say, well, if this Parliament has been unconstitutional, then A, B, C, D, E laws that it has also passed are also not constitutional, since the body that is passing them wasn't legally constituted?
I'm not sure that the Chief Justice was really saying that. And as I said, in that original Supreme Court case, the only person who really was focusing on that was William Matonga, the Chief Justice at the time. Basically, the Chief Justice's statement is really focused on this provision that says you can be given a deadline by this High Court.
Yes. If
you don't meet that deadline, I have this, in fact, duty to advise the President to dissolve. And he's not focusing on, it's not because Parliament is actually unconstitutional. Mm-hmm. It's simply because there is this procedure which is intended to push Parliament into complying with the constitutional provision. Okay. Yes, it would be a terrible mess if Parliament were told you are unconstitutional. It has, these things have come almost to that in some countries. Can I give you just one interesting example?
Yes, I mean, please share, precedents and examples.
In Canada, a number of years ago, the province of Alberta, I think it was,
in Canada.
In Canada, was revealed in a case before, a case that went up to the Supreme Court, to have been in violation of the Constitution, because the Constitution directed that all legislation, all law, must be published in English and French. And they'd only done English. And the Supreme Court was very firm that you have to do the French, but they were able to. They were able to say, but obviously we'd be causing real chaos if we said all the laws you passed that should have been in French as well are no longer valid, and therefore we're going to give you a deadline to sort all that out, produce them all in French as well, and after which, but if you don't, then your law will become, your laws will become invalid. Alberta, they must have had a sort of 24-hour-a-day translation service going on or something to get all their laws put into French as well, and they achieved that, I think. I think one of the problems that we faced with our Parliament is they didn't actually believe anybody would use the nuclear option. And they've almost decided to call everybody's bluff. Yes. And now they're finding that actually it's their bluff that is being called.
One of the debates has been around, what we are living through that has led to this decision is really a political failure by the political class, by Parliament, to act over all these years, that the sort of context that you've laid out. And one of the issues that I've heard discussed, and the questions that it causes, is to what extent are we continually transferring our political problems to the judicial branch, constitutionalizing our politics and our political failure to a branch. We take our political problems to the Constitutional Court, at our own risk, in a sense, that, you know, in a sense, the judges of the Constitutional Court are not elected. It's almost as if MPs abdicate and kick the ball into the Constitutional Court, and then get totally surprised when the decision is made. And what kind of implications does this have, from your experience, on the politics of a country and on the judiciary? Because this has caused quite a lot, as you know, the nuclear option has caused quite a lot of course, public debate and discussion, a lot of opprobrium directed at the judiciary, which is sort of a continuation of a process that has been there, poor relations between the executive and the judiciary. But just your reflections of when things get to this point where the nuclear buttons are being pushed, their institutions tend to get damaged, and how does one navigate through that?
No, it is a very real problem. India has faced this difficulty for ever since, I think, 1975, or a few years after that, when 1975 was the year when Indira Gandhi declared a state of emergency, and this changed Indian politics very markedly. It also changed the senior judges very markedly, and they had been too deferential to the Prime Minister, who was being pretty autocratic by that stage. And they set out to sort of redeem themselves almost by being far more activist. And that the approach they took then has sort of rubbed off on many other countries, including South Africa, in their constitution, and it sort of filtered down to us as well.
Okay.
I have a favorite quotation from one of the Supreme Court judges in India at the time. And he said, "It's not the judges that have failed the people of India. It's the legislature and the executive." And this was a guy called Chinava Reddy. But the problem still remains. And there have been comments that, in a sense, when the judges take over saying what should happen, then you're almost letting the elected representatives off the hook. They're sort of less pushed. The trouble is that from our point of view, neither do the politicians change, nor do they take any notice of what the judges say. But let me also say, out of fairness, that I have read that something like, at least a third, if not more, of the decisions made by the Indian courts, which are fairly radical decisions and saying what ought to happen, are also ignored by government. Okay. It's not, our government is not unique. Okay. And the problems of tension between executive and judiciary, it's of course happening in many other countries in Africa.
Yes.
There were the cases in Malawi and Zimbabwe, I think, and Zambia and so on. And interestingly, if I may say this slightly differently, today Yash and I spent part of the day on a webinar book launch happening in Hong Kong, or at least come from Hong Kong, and that was about the whole issue of the recent security laws passed by China.
Correct.
But one thing we learned was that the Chief Justice of Hong Kong has issued an 18-page statement saying, what is the job of the judges? Oh. And how should people respond, in sort of, in a sense, defending the judges?
Yes.
We're also fascinated that our friends and colleagues there were saying, it shouldn't have been for the Chief Justice to do this. Yeah. It should have been for their equivalent of the Attorney General. But what an echo of what was being said here. When Maraga stands up for the judiciary, people quite rightly say, where is the Attorney General? Who should be defending the judiciary? So it is a problem. It does set, and it's countries all over the world. Yes. You can see it in the UK, how the hostility to particularly, of course, the European Court of Human Rights, yes. But even to the English judges who are applying the European Human Rights Convention
Yes.
They face very, very similar criticisms.
Okay.
So there isn't an easy answer, but when there is one branch of government which is trying very hard to stand up for the Constitution, well, certainly those of us who are lawyers feel a certain supportive sense of vis-a-vis the judiciary.
Correct. Thanks. If I was going to ask Gil, in the perfect scenario, what's the transition now? What are the next steps? What happens now? What's the neatest way out of the paper bag into which we have jumped, sealed ourselves?
That's a very interesting question, because I suppose the neatest way is actually something that would be technically a violation of Article 261 of the Constitution. Because what's worrying me about this whole business of the article of the Constitution is that, as I say, technically I think the Chief Justice, so the President has no choice now.
Yes.
He has a little bit of choice because the Constitution doesn't give a deadline. Okay. And you may have seen that debated. And some people have said he doesn't have a choice. Some people at the opposite end of the scale say, oh, well, he can just leave it to 2022.
Yes.
That seems to be, I think both of those are a bit going too far. Yes. The Constitution does say that if you're supposed to do something under the Constitution and no time limit is imposed, it should be done within a reasonable time.
Okay.
I think the technical position is that really the President is supposed to make a decision and dissolve Parliament within a reasonable time. And I would agree with that maybe a pandemic is a relevant factor for him making the decision.
Yes.
But there is a serious problem. Some people don't entirely agree with me. It's a problem that, again, under that same article of the Constitution, if Parliament is dissolved,
yes,
there is a general election. We get a new Parliament. Article 261 says a new Parliament elected because, for this reason, the time limit thing starts all over again.
Uh-huh.
And the time limit is 5 years.
5 years, yeah.
Parliament has 5 years. So there's nothing, it won't bite. No. There's nothing in a legal sense to push them to comply with the order ultimately of the Supreme Court. So that seems a bit of a mess to me.
Yes.
Now, and as I say, I think that technically the President doesn't have a choice, but we know that the President doesn't accept that when the courts tell him to do something, he has to do it. Otherwise, there would be 41 judges who have been promoted or appointed, but he has refused to do anything about them. So I have my doubts as to whether he will do anything. But if he did dissolve Parliament, then they'll be faced with a new Parliament that doesn't actually technically have that same deadline. Suppose he said something like, yes, I realize I should do this. This is what the Constitution says. But especially because of the virus and other things, I'm minded to give them a bit of time.
Okay.
If they could do this within, maybe he would pick up the same time limit, 2 months. Yeah. If they sort of can pass the necessary legislation within 2 months, then maybe I just won't obey this. And as I say, technically that may be something he shouldn't do. But I suspect a lot of people would be happy if you somehow said there's one last throw, the sword of Damocles can hang over you for another 2 months.
Yes.
If you don't do it, I will then cut whatever it is holding the sword up. Yeah. But maybe something like that will happen. My other worry is, and that also has been raised in the newspapers at least, is the BBI.
Correct.
That his attitude may be, and not only his attitude, in fact, I think some women politicians who were, I think, visiting maybe the president the other day, would like to add this to the sort of the basket of goodies that some people are hoping that will be delivered by the BBI. Not just jobs for people from the 5 big communities and so on, but the other things that people are sort of throwing in. And the latest one seems to be the possibility of saying, okay, what of course they would then be doing would be to change the constitution. And there are two candidates for changing the constitution. One which would achieve the guarantee of no more than 2/3, and the other one which would push it off indefinitely into the future. I'm not sure which one would be the one that would find its way into the BBI, but I fear one of them would. So this idea that one of the newspapers raised, well, you know, has the Chief Justice given the President another goodie for the BBI, maybe not entirely unjustified.
That's very interesting. So, you know, creating an opening in the door for far-reaching changes.
Yes, that's right. Yes, and also helping, or imagining anyway, that a lot of new people might buy into the BBI because this is the thing they want.
Correct.
It's a bit like the fears we had in 2010 about the different groups of people who had reasons for not passing the constitution, approving of the constitution. We now have the opposite situation in which people are trying to add things to the BBI, and each new idea is supposed to bring in another collection of votes for the BBI and the referendum, which would have to follow or be part of it. So since I'm not very keen on the BBI, this is another, another cause of concern for me.
Correct. Just, you know, as sort of time runs away from us, and one sort of broader philosophical question: the framing of the whole narrative around the decision made by the Chief Justice that the President has to implement. You know, it's painted very much as about women in Kenyan society, and there are those who are painting it as, oh, you know, this is a feminist agenda that is being imposed on Kenyans, etc., etc. I just wanted you to reflect, you know, given the sort of the deep and long involvement that both yourself and Yash Ghai have had in the development of the current constitution in Kenya. You know, what was the spirit that informed? Because, you know, I think in a sense the 2010 constitution is an excellent document, but people sometimes don't talk enough about the process that led to this constitution. We're going around the country listening to ordinary people, and I just wanted you to give us a flavor of the spirit that informed what is now called the 2/3 gender rule.
I think I was very much personally sort of on the sidelines. On the other hand, I was here quite often. I often think of those of us who are old enough to remember the Suez Crisis.
Yes.
And when Anthony Eden was Prime Minister for a rather short and unfortunate period, yes. When the Suez Crisis of 1956. But his wife, Lady Eden, said she felt as though the Suez Canal ran through her sitting room. I felt that a bit about the constitution-making process. But it's, I think one striking thing was that this particular issue about decent representation of Kenyans as a whole, not just, and in fact, there's a very nice phrase in the in one of the best documents, I think, that the Constitution of Kenya Review Commission produced, which was called the Short Report, says the commission had gone out traveling around the country listening to people, and it found a nation in which everybody felt marginalized.
Yeah.
Everybody felt that somehow they were not properly involved. Yeah. Sometimes they could put it down to being woman or from a particular community, particular religion, particular language. Otherwise, they simply felt that just the people were not properly included.
Yeah.
But the issue of women was definitely prominent. It had been there during much of the 90s, and growing during the 90s. With, of course, many very prominent women, quite a lot of whom ended up in the Committee of in the CKRC and then in BOMAS, who had been very active and had been preparing and had been trying, including the motion, I think it was 1997,
yes.
In Parliament to ensure decent representation of women, and the process of making sure that at least women were involved in the constitution-making process, which, and yes, and they were very active, and let it be said in defense of my husband, who's chairing the process, he tells me that he tried to persuade the CKRC to accept the idea that we should just have a smaller number of larger constituencies, and every constituency should have a man and a woman MP. But wouldn't that have been a simple solution?
Yes.
It would have been 50% of each gender.
Yes.
None of them would have come in on a different basis, so they wouldn't be called bonga points and the other insulting phrases that has been used of the women who are, quote, nominated.
Yes.
There wouldn't have been any puzzlement as to what they were doing there and what their role was. It would have been just the same. So I think it's really unfortunate. But nonetheless, it was quite clear that this was a really dominant and important element, along with representation of other groups too, throughout the process going right back to the beginning.
Thank you, Jill. You know, it's amazing how quickly 40 minutes run. Yeah. That was really a masterclass for us, sort of neophytes who are sort of listening and watching as the lawyers trade verbal punches on social media around this issue. That has really brought a lot of clarity. I know this is going to be a moving target. It's going to continue, and I know that you're going to remain engaged. So I'm just seeking your indulgence and permission to be able to come back to you to seek your advice and counsel on this issue on an ongoing basis.
You'll be very welcome, Tom.
Thank you. Thank you very much. And thank you very much for your time this evening, Jill.